I want to begin first by saying thank you for all the staff and everyone that made this event possible. I also want to say that the previous two speakers definitely is going to make my job a little bit harder. I want to start off by building on Lou's theme, which was an expansion of presidential power. Mine is in the context of executive privilege and presidential secrecy. Now, executive privilege, broadly defined, is a concept that there are certain executive branch documents that, for the necessary functioning of that institution, should be protected from disclosure. Now, President Bush came into office right away thinking he needs to expand executive privilege. And much of that was, in his view, that power was ceded by previous administrations. So he made a concerted effort to expand executive privilege for that very result. Now, this isn't to say that Bush was the first president to try to expand executive privilege. Certainly, President Richard Nixon had done so, resulted in a Supreme Court case. Currently, or more recently, President Bill Clinton had tried to expand executive privilege in several high-profile cases. Now, the Supreme Court has stated that the executive privilege is constitutionally based. However, it is not an absolute privilege. It can be overcome. It can be overcome by a showing of wrongdoing or congressional need. That is, congressional need in its oversight or legislative capacity. U.S. versus Nixon, several high-profile D.C. post-Watergate cases, and really the inner workings between President and Congress have really laid the groundwork for what really is executive privilege and how you define it. It's relatively an amorphous concept, but by and large it has four general justifications, or at least four general justifications are given by presidents for declaring executive privilege. The first is national security, military affairs, and foreign affairs, kind of a subgrouping there. The second is an ongoing criminal investigation. The third and fourth justification, the deliberative process privilege and the presidential communications privilege, are often grouped together, but are distinct privileges in themselves. The deliberative process privilege applies to executive branch officials generally and only protects pre-decisional information, not anything to do with factual information or when a president or one of his advisors has made a decision. Now, this is a common law privilege, which means it has a very low threshold to overcome. Basically, it disappears altogether, this privilege, if there's any understanding of wrongdoing on the part of the executive branch. And also, it can be overcome by a congressional need. And almost any congressional need will at least defeat a claim of executive privilege on deliberative process, or at least it should. The fourth one, as I said, presidential communications privilege. This is a little bit tougher. This is constitutionally based. It was announced in U.S. versus Nixon. It is tied directly to the president. It is tied to the president in his decision-making capacities and what are considered quintessential presidential powers. So, for instance, pardons, appointments, so on and so forth. It takes into consideration, or it protects more than just pre-decisional information, it protects all information. However, you cannot stretch this out through the entire executive branch. Recent case law has shown that it's actually cabined within the White House Executive Office of the President. So actually the President and only his immediate advisors get to use the executive communications privilege. Now, with that said, oftentimes the claim of executive privilege is going to be justified under the deliberative process privilege, and usually one or more of the others. I would actually say or comment that deliberative process privilege has been used far too much by this administration and previous administrations, namely President Bill Clinton. I want to actually summarize here what I think of the executive privilege claims during the Bush administration, which for many, the legal reasonings, the underlying legal reasonings within executive privileges claims have been flawed and I believe most likely will have the opposite effect than what President Bush intended them to have, which was an expansion of presidential power. I believe that his successors will see his use of executive privilege as the way not to go. And I want to highlight 4 cases here of executive privilege and secrecy in general. The first 3 happened early on in his administration, 2001, 2002. So you can see right off the bat, he sort of hits the ground running with executive privilege. The first case has to do with a claim of executive privilege on documents related to a closed Department of Justice investigation into FBI corruption with the Boston mob. The House Government Reform Committee began investigating this issue. They asked for documents. The president said no to disclosure and claimed executive privilege. This is a unusual case to place a claim of executive privilege on, in the sense that this wasn't dealing with an ongoing criminal investigation. This criminal investigation had closed 20 years before this. So eventually, the 2 sides, Congress and the president, they go back and forth for a number of months, and eventually the information is provided. Congress won. Not the greatest case, obviously, to start off with if you want to expand presidential powers if you're George W. Bush. He did succeed in one aspect with this case, I must say. This is the first time, and I believe the only time, and people here could probably correct me on this, I know it's the first time that the Republican committee, and remember, Congress is controlled by Republicans early on in Bush's administration. The Republican committee, every member of the House Government Reform Committee voted for or in support of this the subpoena of documents. And so they voted against, in essence, President Bush's position of expansion of executive privilege. So there, at least, he can lay claim to being the first time that a Republican Congress had pushed up against the president. And this is a remarkable time in a sense. It's right after 9/11. The president has high approval ratings. Largely early on in his administration, the President Bush was given due deference by members of Congress, especially Republican members of Congress. So this is the first, and I believe the only time, where you've seen this level of pushback on executive privilege claims. My second case for expansion of executive privilege was for an executive order. President Bush issued an executive order in 2001. This executive order had to deal with the Presidential Records Act of 1978. Basically, this act establishes procedures for the public release of presidential papers. The theory is that presidential papers are not private property of the president. They are public information, and they should be made public within a reasonable time period. The only substantial change from 1978, when the act was passed, until 2001 was Ronald Reagan executive order. And this executive order identified 3 areas where records may be withheld from the public. 1 was national security, 2 was law enforcement, and the 3rd area was the deliberative process privilege. Reagan also gave the sitting president primary authority to withhold information on records of a prior president. Not too much of a big leap in terms of presidential secrecy, but again, guarding information, some of these things were actually a little bit redundant in the sense that the Freedom of Information Act and some other laws actually protected these presidential papers, so the order was a bit redundant there. Now, in 2001, President Bush partially overrode Reagan's executive order and vastly expanded the scope of the privileges available to current and former presidents. So now former presidents could claim a privilege on their papers. It had a much more great capacity to claim privilege on their papers. First, what he did was he dropped the law enforcement category that Reagan created, and he added the presidential communications privilege and the attorney-client privilege. He also allowed for former presidents to assert privilege on their own papers